these victims and more than 1,000 like them. The DOJ is not doing its job. Will you create a task force with state and local law enforcement to make that happen?
Mr. Chairman.
Well, you know what? If he were part of the Epstein investigation, you wouldn't do anything about it.
Online chat room. Who he was?
Mr. Chairman, she's embarrassing you.
He's about to be
This is your committee, and she is embarrassing you.
There are moments in American political history that stop you cold. Moments where you watch something happen in a congressional hearing room and think, did that just actually happen? Did a sitting president of the United States just file a $10 billion lawsuit against his own government, being decided by his own political appointees over the leak of tax returns that the American people always had a right to see? And did that same administration simultaneously expose the private names, home addresses, and phone numbers of women who were sexually abused as children, and then do nothing about it? Because that is exactly what Congressman Jamie Raskin forced into the open during one of the most explosive congressional hearings of 2026, when he sat across from Attorney General Pam Bondi and refused to let the American people be deceived without a fight. Welcome back to the channel. If this is your first time here, please hit that subscribe button right now and turn on the notification bell, because we cover the political stories that demand your attention, the ones the mainstream news cycle moves past too quickly, the ones with constitutional consequences that will affect every American for years to come. Today's breakdown is one of those stories. We are going deep into the Raskin and Bondi confrontation, the $10 billion IRS lawsuit, the Epstein survivor scandal, and what it all tells us about the two-tiered system of justice that is operating at the highest levels of the United States government right now.
Article 2, Section 1, Clause 7 of the Constitution is the Domestic Emoluments Clause. And it says that the president is limited to his salary in office and cannot receive any other money from the federal government while he's in office. It cannot be increased by $1. This president is the first president in U.S. history who has repeatedly sued the federal government for $230 million for the judicial search warrant at Mar-a-Lago, which was perfectly lawful and was never struck down. But now he's suing the IRS for $10 billion. He's suing the IRS for $10 billion, which I think is around 80% of its annual budget, because his tax returns were leaked. And they were illegally leaked by a private contractor who actually is in prison now, Charles Littlejohn. But he wants $10 billion. Now, I want to ask you the question of whether you think it would violate the Domestic Emoluments Clause for you to settle that $10 billion case or any of the other claims that the president has made against the government. He himself has remarked, it's interesting because I'm the one that makes the deal, right? And he says, I kind of have to work it out with myself. Do you think it would violate the Domestic Emoluments Clause for the president to work out a deal from people who are his subordinates under his unitary executive theory to get money in one of these cases?
I'm not going to discuss pending litigation.
Okay, so theoretically you're saying because his privacy rights were violated in that tax case, and they were. I'm with the president on that. I mean, his Mar-a-Lago thing is ridiculous, but there's no doubt that his tax returns, despite the fact that he promised to release them, despite the fact that every other president released the tax returns, he suffered embarrassment when it showed that he hadn't paid taxes for several years, and he had a right for that not to happen. Now, I want to turn back to the Epstein survivors, because President Trump may have been a little bit embarrassed by the release of those tax returns. How much do you think the claims of these survivors are worth? As the good congressman from Kentucky just pointed out, there were lots of survivors who had decided, for reasons of their own, never to release their names. That determination was represented to people in Congress, and we built it into our federal law that their names could not be released, and yet you published their names, their phone numbers, their addresses, personally identifying information. If Donald Trump can get $10 billion theoretically from the Department of Justice, how much should these people get for a far worse violation of their privacy rights and a far greater danger established to them in their lives?
Do you even know who Chase Mulligan is? You're so obsessed with, you
Okay,
don't, do you?
I'm going to teach you the
just made a
rules again.
face.
You're the Attorney General of the United States. We have rules here.
You're obsessed with him.
You're the Attorney General of the United States.
With
And the rules,
obsessed with Donald Trump. You
No.
have Trump derangement syndrome.
Mr. Chairman,
Chase
I'd like my time
Mulligan will be
restored. I'd like my
sentenced
time
next week
restored.
in your district. In your district,
Stop
and
the
you don't
clock.
even know about it, about keeping children
Time belongs
safe
to
from
the
online
gentleman.
predators.
Time belongs to the gentleman from Maryland. The gentleman can proceed.
Yeah, and I want the whole country to look at this. Because this is the Attorney General of the United States, whose job is law enforcement. We've never had a witness who has misunderstood our rules and been unable to conform his or her conduct to our rules before. We have only 5 minutes, and so we use our time to ask you specific questions.
How long are you giving me to
Excuse
answer?
me, I'm not yielding to you right now. I'd like that second restored too. So, Ms. Bondi, the way it works is we ask you a question and you answer it, and if you go off on a wild goose chase, another tangent, you start reading statistics or you start talking about stuff going on in our district. And by the way, I invite you to my district. Come to my district, but that's not what we're here to do today. Okay? So, and you do that, then we're allowed to say we reclaim our time. At that point, you have to be quiet. You have no choice. You have to be quiet. So I hope you understand the rule at this point. Now, here's what I want to ask you. You're in law enforcement. We've seen all kinds of evidence of crimes. And when we go over to the Department of Justice for the 4 computers for every member of Congress, we see more evidence of crimes. Will you create a joint task force of the Department of Justice and governors and state attorney generals and district attorneys across the country to investigate the crimes that have taken place against these victims and more than 1,000 like them? The DOJ is not doing its job. Will you create a task force with state and local law enforcement to make that happen?
He called Chase Mulligan a wild goose chase and didn't even know who he was. He is a defendant in your own
Chairman,
district who
Mr.
preyed
Chairman.
on girls.
Mr.
ages
Chairman.
15
Well, you know
to
what? If he were part of the
17
Epstein
in
investigation,
social
you wouldn't
media
do anything
and
about it.
online chat rooms and committed sextortion. Yet he didn't even know in your tiny little district who he
Mr. Chairman,
was.
she's embarrassing you.
He's about to be
This is your
fined.
committee, and she is embarrassing
Shame
you.
on you.
The time of the gentleman has expired. I would remind the committee that last Congress, Secretary Mayorkas was here numerous times, and he wouldn't answer our questions, even when we sent them to him ahead of time in writing. So that's what we've had to deal with. I think the Attorney General is doing just fine. We have votes shortly.
All right, so if you're sitting there thinking, what the hell did I just watch? You're not alone. Trump is suing the IRS for $10 billion. In January, President Donald Trump, along with his sons Donald Trump Jr. and Eric Trump, and the Trump Organization, sued the Internal Revenue Service and the Treasury Department for $10 billion, arguing that the agencies failed to take measures to protect his tax information.
And more breaking news tonight from a Miami federal court where President Donald Trump is suing the IRS for allegedly leaking his tax returns. The lawsuit puts Trump, his sons Eric and Don Jr. and the Trump Organization up against the Treasury Department, suing for $10 billion in damages. The lawsuit claims an IRS employee leaked the Trump's confidential tax returns to media outlets, including the New York Times and ProPublica. This allegedly happened between 2019 and 2020. NBC News is reaching out to the IRS for a response.
But the IRS lawsuit isn't even the most urgent issue in that exchange. Raskin then pivoted to the Epstein survivors. Thousands of Epstein documents were taken down after victims were identified.
Now to new fallout in the wake of the release of the Epstein files. The Justice Department striking a deal with attorneys for survivors who say their lives were turned upside down when the DOJ failed to redact some of their personal information from the files and then posted those files to the DOJ's website. Attorney Pam Bondi has acknowledged mistakes. The Attorney General saying the department has now taken down several thousand documents that may have included victims' information. Let's bring in MS Now Legal Affairs reporter Fallon Gallagher, Eric Fudali, who represents several Epstein survivors, and former federal prosecutor Barrett Berger. So, Fallon, what do we know about this deal that was apparently reached between the survivors' attorneys and the Justice Department?
Yeah, this hearing was supposed to be happening this hour, and then late last night, Judge Berman issued a single-page order canceling the hearing, saying that the survivors' attorneys and DOJ reached a deal to resolve those privacy issues in an expeditious and meaningful way to prevent future harm. There were very few details in that order, and we have not seen anything official from the Department of Justice, but we do know what the survivors were asking for. Their lawyers had submitted a letter earlier this week saying that they needed the Justice Department to resolve these issues and remove any identifying information. You'll remember that there were a plethora of material of names, photos, other identifying information that was not redacted properly. They have a list of 350 survivors' names, and they want that material corrected. So they have asked for it to be taken down and fixed, or they've asked for the entire website to come down. Now, we know that DOJ, in a separate letter, has said that they have removed several thousand files, pages, and that they're going through and correcting those redactions, and I would presume that they will be back up. But again, we don't know the specifics of this deal. We just know that the judge was appeased enough to cancel today's hearing.
And so, Eric, it was the victims, the survivors, who worked so hard to get these files released. They wanted transparency, they want accountability, and they trusted that their personal information and privacy would be protected. And now the files are released, but they say their lives have been turned upside down again. What are your clients experiencing?
Well, that's absolutely what's going on. I'm not sure if it's intentional or it's incompetence, but what is very clear is that the DOJ has disregarded the well-being of the survivors. One of my clients was named 538 times in the latest release of Epstein files.
Wow.
538 times. Of course, we immediately alerted the DOJ. As of yesterday, it was down to 2 times, but 1 time is too many times. It is unacceptable. They have had so much time to do this. And this is just simple redactions. It's just redacting names. This is not rocket science. And the whole reason they're claiming that they're basically late, they violated the law and they were almost a month and a half late to reveal these documents, is they needed to redact. Right. But what were they doing for this time? 538 times is just beyond comprehension and competence.
One person.
One person. And she was not the only one of my clients whose name was released unredacted in these files. It's incompetence and it's just unacceptable.
Barrett, the judge writes that he is, quote, pleased but not surprised that the DOJ and survivors' attorneys were able to resolve this on their own. But just how bizarre is it to have gotten to this point where a judge nearly needed to get involved in protecting sex abuse victims because of such an apparent failure of the Justice Department?
I mean, redacting victim information is not an issue that is unique to this Epstein investigation. This is something that federal prosecutors deal with in every case involving sensitive victims, involving child victims, or involving sex trafficking, period. This is something that DOJ attorneys know how to do. They do it in every case that involves these kind of victims. And the fact that this information was included is so tragic for the victims because you can't unring that bell. You can't get that information out of the digital sphere. I'm glad they reached the agreement, but DOJ was facing some real risks there, both for potential civil lawsuits down the road from people who had had their information compromised and potentially some sort of contempt of court. So DOJ was certainly in no position to fight this, and it's promising that they reached a settlement as quickly as they did with the victims' attorneys.
I mean, some survivors say they've been getting death threats after their private information was left unredacted. So you can't put that toothpaste back in a tube. The New York Times found dozens of uncensored images of naked women with their faces visible. The Associated Press found multiple incidents where names and faces were obscured in one document only to be left in another.
I really appreciate you for watching, and make sure to check out this one.
Let's start with the lawsuit, because you have to understand what Donald Trump actually did here before you can appreciate why Raskin was so furious. On January 29, 2026, Donald Trump, along with his sons Donald Trump Jr. and Eric Trump and the Trump Organization, filed a $10 billion lawsuit in federal court in Miami against the Internal Revenue Service and the United States Treasury Department. The lawsuit alleges that the IRS failed to protect Trump's confidential tax information when, between 2018 and 2020, a government contractor named Charles Littlejohn illegally obtained Trump's tax records and leaked them to the New York Times and ProPublica. Littlejohn pleaded guilty in October 2023 and is currently serving a 5-year prison sentence. That part of the story, the contractor, the crime, the conviction, is not in dispute. What is in dispute is everything that comes after it. Because here is what Trump is now arguing, that the leak was so devastating, so damaging to his reputation and his business, that he, his family, and his company deserve a minimum of $10 billion in compensation from the American taxpayer. $10 billion paid by you to the president for the leak of tax returns that, in the view of many Americans, should have been made public while he was running for office in the first place. But here's where the story goes from outrageous to constitutionally unprecedented. In any normal lawsuit, you have a plaintiff and a defendant. They are separate parties with separate interests, separate lawyers, and a neutral judge overseeing the process. But in this case, the plaintiff is the President of the United States, and the defendants are federal agencies that he personally oversees and controls. The IRS and the Treasury Department do not operate independently of the White House. They answer to the executive branch. They answer to him. And the people who would make the decision about whether to settle this lawsuit and for how much, that would be Attorney General Pam Bondi and Treasury Secretary Scott Bessent, both of whom are Trump's own political appointees, both of whom owe their jobs entirely to his goodwill, and both of whom, in Bondi's case, previously worked as his personal defense attorneys before being appointed to lead the government agencies that are now supposed to defend against his lawsuit. Think about what that means. The president is suing. The president's loyalists are defending. The president's loyalists decide whether to settle. The president collects the check, and all of it is paid with taxpayer money from what is called the Judgment Fund, a pool of public money set aside to cover government liability. Legal experts across the political spectrum, including conservatives, have called this what it is. Edward Whelan, a former Justice Department lawyer who once clerked for the late Justice Antonin Scalia, not a liberal, not a Democrat, described it as a glaring conflict of interest and warned that the fear many people share is that the Department of Justice will simply fold and ask Donald Trump, the individual, how much money Donald Trump's administration should funnel to him. A professor of legal ethics at NYU School of Law put it even more bluntly: Trump is essentially suing himself for his own negligence. The leak happened during his first term, under his own Treasury Secretary, under his own IRS Commissioner, under the watch of his own administration. And now, more than half a decade later, he is demanding $10 billion from the government for failures that occurred on his own watch. The timing of the lawsuit made things even more suspicious. Just 3 days before Trump filed the suit, the Treasury Department quietly canceled $21 million in contracts with Booz Allen Hamilton, the consulting firm that employed the contractor who committed the original leak. The cancellation came more than 5 years after the breach, and it came right before the lawsuit was filed. Democratic Senators Ron Wyden and Elizabeth Warren immediately demanded answers, writing to both Bondi and Bessent, asking whether the agencies intended to challenge the lawsuit or capitulate to it. In their letter, they wrote something that cut right to the heart of it. This is not compensation for proven harm. This is a president seeking a $10 billion windfall at taxpayer expense. They pointed out that Trump is simultaneously supervising the private attorneys demanding the damages while also overseeing the senior Justice Department attorneys with authority to settle the case. One ethics expert quoted in their letter called it the risk of the most collusive lawsuit of all time because the president is suing a defendant whom he says has to do whatever he directs. They haven't received a response. Bondi's office didn't comment. The Treasury and IRS stayed silent. When Treasury Secretary Bessent was asked about the conflict of interest during a February Senate Banking Committee hearing, he testified that he was deferring to the Justice Department on the matter, but that he would pay the $10 billion if directed to. He would pay it, if directed, by the president. Let that sink in. This is the context Congressman Raskin brought into that hearing room when he sat down across from Pam Bondi. He did not come to exchange pleasantries. He came to ask the question that the American people deserve an answer to. Can a sitting president legally collect money from the U.S. Treasury, the government he leads, while he is in office? Because if the answer is yes, and if that settlement goes through, Raskin argues it would violate the Domestic Emoluments Clause of the United States Constitution. That clause, found in Article 2, Section 1, is clear. The president shall receive a fixed salary for his service and shall receive no other financial benefit from the United States or any individual state while in office. It was put there by the founders to ensure that the president could not use the power of his office to enrich himself. It was designed for exactly this kind of moment, and Raskin pressed Bondi on it directly, asking her whether she believed that Trump settling this lawsuit with his own subordinates would be constitutional and legal. Her response was a masterclass in institutional evasion. She said she was not going to discuss pending litigation. She repeated it. She pivoted. She filibustered. She ran out the clock every chance she got. And Raskin, with his minutes ticking away, eventually had enough. He raised his voice. He demanded that she stop talking and let him ask his questions. He reminded her, loudly, clearly, and unmistakably, that he controlled his allotted time in that hearing room and that she was there to answer questions, not to bury them. It was one of the most striking moments of congressional oversight in recent memory, not because of the volume, but because of what it represented. Here was a constitutional scholar, a man who spent his career studying the separation of powers, staring down an attorney general who he believes has transformed the Department of Justice from an independent institution into a personal legal services firm for the president, and he refused to pretend otherwise. But the confrontation did not end with the IRS lawsuit, because Raskin then pivoted to something even more devastating. A contrast so stark, so morally clarifying, that it exposed the double standard at the heart of this administration's approach to privacy, accountability, and justice. He turned the conversation to the survivors of Jeffrey Epstein. Here is what you need to know. In November 2025, President Trump signed into law the Epstein Files Transparency Act, a bipartisan piece of legislation that required the Department of Justice to release its files related to Epstein and his co-conspirator Ghislaine Maxwell. The law was celebrated across party lines. The American public had been demanding transparency about Epstein's network for years. The files were supposed to reveal who had enabled him, who had protected him, and who had been involved in his decades of abuse. And the law was explicit. In releasing those files, the DOJ was legally required to redact the names and private information of survivors, the women and girls who had been victimized, many of them as minors, who had never chosen to have their identities made public and deserved the protection of the law. What the DOJ actually did was a catastrophic failure of that legal obligation. In late 2025 and January 2026, as the department began releasing millions of pages of documents, attorneys for Epstein survivors immediately began sounding the alarm. The redactions were not just incomplete, they were riddled with thousands of errors. A Wall Street Journal review found that at least 43 victims' full names had been exposed in the files, including more than 24 who were minors when they were abused. Some of their names appeared over 100 times in the documents. Home addresses were visible in keyword searches. Bank account information was included without redaction. An email listing 32 minor victims had only one name redacted. The DOJ had been given, on December 4th of the previous year, a list of 350 survivors by their attorneys, a list of people whose names needed to be protected. The attorneys said the department failed to perform even a basic keyword search to verify its own redaction process. There were, in the words of the attorneys, literally thousands of mistakes. Nude images of young women, some of whom appeared to be minors, were published with faces visible in the document dump. They had to be removed only after the New York Times began notifying the department that the images existed in the files. Survivors and their families were horrified. Sky Roberts, the brother of Virginia Giuffre, one of Epstein's most vocal survivors who died by suicide in 2025, told reporters that the DOJ was putting women at risk who never wanted their names publicized. He said they were redacting the names of perpetrators and unredacting the names of victims, exactly the opposite of what the law was designed to do. The attorney for multiple survivors put it without any diplomatic softening. The Department of Justice does not care about victims one bit. The consequences for those survivors were immediate, severe, and ongoing. Strangers began calling them. Emails flooded in. Threats were made against their physical safety. Some were accused of conspiring with Epstein, accused of being willing participants, when in reality they were the people Epstein had spent his life exploiting and abusing. Attorneys filed an emergency request asking courts to order the immediate takedown of the DOJ's Epstein Files website, describing the situation as an unfolding emergency where every hour of delay caused irreversible harm. The DOJ eventually removed some of the files, blamed the errors on technical and human failure, and said it was working around the clock to fix the issues. But the damage was done. The information was already out in the world. And then came the next dimension of the problem: Google. Even after the federal government removed or corrected portions of the files, Google's artificial intelligence search tools continued to surface the private information of survivors in search results, cached pages, and AI-generated summaries. Lawyers ran tests. They entered the names of their clients combined with keywords like Epstein, victim, or survivor, and Google's AI tool returned the women's full names, email addresses, home cities, and direct clickable links to send them emails. One victim notified Google directly that her information was being displayed. It wasn't changed. The information stayed up. Her name, her contact details, her connection to Epstein, accessible to anyone with an internet connection and a search bar. As of the end of March 2026, approximately 100 survivors have now joined a class action lawsuit filed in federal court in California, suing both the Department of Justice and Google for the wrongful disclosure and continued republication of their private information. The complaint states plainly that the DOJ made a deliberate policy choice to prioritize rapid, large-volume disclosure over the protection of Epstein survivors' privacy. Not an accident, a policy choice. This is exactly what Raskin brought into the hearing. He sat across from the Attorney General of the United States, the same Attorney General whose department exposed those survivors, whose department published their names and addresses and phone numbers, and he asked her the question that the moment demanded. He asked her why the Department of Justice was moving with aggressive urgency to protect the president's financial privacy by pursuing a $10 billion lawsuit for a tax records leak, but had failed so catastrophically to protect the privacy of women and children who had survived one of the most horrific sex trafficking operations in modern American history. He asked her, if Donald Trump can get $10 billion for a tax leak, how much should these people get for a far worse violation of their privacy and a far greater danger established to their lives? It was not a rhetorical question. It was a constitutional and moral indictment of an administration that has made clear, through its actions, whose privacy matters and whose does not. The president's financial embarrassment, his tax returns, his business dealings, information that voters arguably had a right to know, that gets a $10 billion lawsuit paid with public money. The survival stories of women and girls who were abused and trafficked, their names, their home addresses, their phone numbers, their identities, those get exposed to the internet and the threats and the harassment that follow. And when Raskin demanded that Bondi address this, demanded that she at minimum commit to creating a joint task force with state and local law enforcement to pursue new accountability for the broader Epstein network, she had no substantive answer. She deflected. She pivoted. She talked past him. And Raskin once again made clear that her evasions were not acceptable, that silence from the highest law enforcement officer in the country is not a neutral act. It is a choice, and it is a choice with consequences for real people whose lives have been turned upside down. What this hearing revealed, in the starkest possible terms, is the operating logic of an administration where power determines protection. The president has power. His financial privacy is protected by a $10 billion lawsuit that his own appointees will decide. Epstein survivors do not have power. Their physical privacy, their personal safety, their right not to be re-traumatized and exposed to public harassment, those protections failed, and the Department of Justice responsible for the failure has offered no accountability, no compensation, and no meaningful legal action. There have been 0 new indictments against Epstein's broader network, despite millions of documents now in the public record. Not one. And when Raskin challenged Bondi on that paralysis, she reached for the same tool she had been using all morning: deflection. The story does not end in that hearing room. In the days following the exchange, a deal was reportedly reached to temporarily take down portions of the Epstein files database in order to address the ongoing harm to survivor privacy. A partial concession that came only because of relentless pressure from attorneys, survivors, lawmakers, and journalists. But even that victory was incomplete. Even after the government removed the files, Google continued to index and serve the data. The technology companies that profited from the visibility of those documents showed no urgency to protect the people whose lives were being damaged by their algorithms, and the $10 billion lawsuit continued to move through the court system, with a federal judge in Miami overseeing a case that may ultimately be thrown out, but may not be. The presiding judge has the discretion to dismiss it on the grounds that it is not a matter for the courts. But if she does not, and if the Justice Department recommends a settlement, the money would come from the Judgment Fund, from taxpayer contributions paid to a president who has already suggested he will give it to charities, he noted, that would be approved by him. This is the America that Raskin stood up in that hearing room to name. Not a partisan America, not a Republican versus Democrat America. An America where the law bends in the direction of power, where a president can sue his own government for billions, where survivors of child sex trafficking can have their names and addresses published online without consequence, where an attorney general sits across from a congressman and refuses to answer direct questions while the clock runs out, and where one of the only checks left in the system is a member of Congress who raises his voice and says, "Stop talking. I control my time. Answer the question." Whether you are on the left or the right, whether you voted for Trump or against him, these are not partisan questions. Who the law protects matters. Whether the president can profit from the government he controls matters. Whether survivors of abuse are entitled to the same protection of their privacy that a billionaire president claims for himself, that matters more than almost anything else on the table right now. These questions will define what kind of country America chooses to be in the years ahead. We are going to keep covering this story as it develops. The lawsuit is still in court. The Epstein survivor lawsuits are just getting started. The DOJ's handling of both situations is going to face more scrutiny, more hearings, and more moments like the one you just learned about today, and we will be here for every single one of them. If this video gave you information you did not have before, the most important thing you can do right now is hit the thumbs up button. It takes 1 second and it directly helps more people find this content. Share this video with someone who needs to understand what is happening in this country right now. The truth does not spread itself. It spreads because people who care about it make the choice to share it. Subscribe to this channel if you have not already, turn on that notification bell, and become part of a community that refuses to look away from the stories that matter. Leave your thoughts in the comments below. We read every single one. Do you think the $10 billion lawsuit should go forward? Do you believe the DOJ failed the Epstein survivors? Tell us where you stand. We will see you in the next one.